Hello, this is Matt on the Moon Lambo channel, and here's a headline from the Crypto Basic. Attorney John Deaton explains why Ripple has not sued William Hinman for his blatant ethical conflicts. Now, Attorney Deaton believes it would be a tactical error to sue former SEC Director William Hinman at this stage in the game. In fact, assuming Hinman did something that was illegal, assuming that's the case, suing him now would likely prevent justice from ever occurring. And we need rather specific evidence, and the XRP community is hunting for it right now, and I'll share with you exactly what that is. But before going any further, I do want to be clear that I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And this all stems from a new thread from Attorney Deaton himself here, which he basically titled here at the top, "Why Not Sue Hinman Now?" It was the first words in his tweet. And it reads as follows. I probably have 100 direct messages asking the above question, and many others are frustrated and wondering why I or others aren't moving forward with a lawsuit against Hinman for his blatant ethical conflicts. Everyone wants justice today. I get it. So do I. The truth is, anyone could file a suit today. But, as of right now, the case would get dismissed with prejudice based on the qualified immunity Hinman enjoys as a former government official. I have said, if Hinman knew his law firm was a member of the Enterprise Ethereum Alliance, and he didn't get approval from the ethics office, which he couldn't, then it would, in my opinion, constitute a violation of criminal conflict laws. But we must prove Hinman had actual knowledge that Simpson Thacher, his law firm, was a member of the Enterprise Ethereum Alliance. So I'll just pause and note, this is what I've been saying this for the longest damn time. I'll say this too. If this information exists and it's publicly available, our community is going to find it because our community is incredibly impressive. Finding the most obscure pieces of information, whether they're written or in video form, hunting them down, searching tirelessly, and then we work as a community to share that information with one another. And so I've been saying, if this is public, if there's something out there that proves that William Hinman knew that his law firm, Simpson Thacher, was part of the Enterprise Ethereum Alliance, that's game over him. He's in some serious trouble at that point because it's also highly likely that he would have lied under oath about it to this point. But I'll go a little bit further ahead in the thread now. Attorney Deaton continues. We don't have proof yet. Only a fraction of Hinman's deposition was disclosed to the public. I guarantee during Hinman's deposition, he was asked whether he knew Simpson Thacher was a member of the Enterprise Ethereum Alliance. I guarantee he said that he wasn't aware of it when he gave the speech. How can I be so sure? Because if he admits he knew his firm was a member of the Enterprise Ethereum Alliance, he incriminates himself. It is a blatant violation of criminal conflict laws. If he admits he knew, he has to admit he should have sought clearance from the ethics office. The ethics office would never approve him giving that speech if it knew his firm was a member of the Enterprise Ethereum Alliance and that he was an active profit-sharing partner, as they concluded. Yeah, but so for those of you who may have missed that, he was determined by the ethics office to be ultimately a profit-sharing partner. So that's why that's like the appearance of improprieties. I think it goes much further than past just the surface level. I think there's, in all probability, I suspect more likely than not, something illegal was done. Now I can't prove that, so I'm not going to make a claim that something illegal was done. But I think it looks bad. And here's the thing. If he didn't do anything illegal, then this is the greatest damn string of coincidences that I've ever seen in my entire adult life. Everything that we've been uncovering for over a year, the biggest string of coincidences that ever, which is why I'm speculating that there very well may be. Fine, don't know. I'm not going to go so far as to make an actual claim that he did something illegal, but man, I'm right on that edge, but I think for good reason. But so anyway, Attorney Deaton continues. Again, he said the ethics office would never approve him giving that speech. He's talking about, of course, the Ethereum free pass speech in June 2018. It would never approve him giving that speech if it knew his firm was a member of the Enterprise Ethereum Alliance and that he was an active profit-sharing partner, as they concluded. They instructed him not to even talk to Simpson Thacher. I have zero doubt Hinman denied knowing about the Enterprise Ethereum Alliance. I have no idea if the Ripple lawyers had evidence to the contrary when they cross-examined Hinman. Unless the deposition is made public or relevant information appears in Ripple's summary judgment papers, we won't see it. This is why we must get an investigation. Now, trust me, Hinman hopes we sue him prematurely. His massive team of high-priced lawyers, along with a team of lawyers from the SEC, will rush to dismiss the case. Hinman and the SEC will show up immediately invoking qualified immunity. Qualified immunity is not immunity from having to pay money damages, but rather immunity from having to go through the costs of a trial at all. Accordingly, courts must resolve qualified immunity issues as early in the case as possible, preferably before discovery. Before discovery. So if a federal judge is not going to let us engage in a fishing expedition and serve discovery requests on Hinman, hoping we find proof of actual knowledge. Qualified immunity shields Hinman and other government officials from being served discovery. We need the evidence up front. So pause. This is what we're talking about. What we're looking for, and what we must find, is proof that he knew that his law firm, Simpson Thacher, was a member of the Enterprise Ethereum Alliance. And we need that information. We need that proof before a lawsuit is begun. Before. I know it's tricky because we're all aware of all the publicly available facts at this point. We know how bad this looks. We understand how XRP holders the world over are getting the shaft as a result of what's going on. But we have to wait a little bit longer. And if we can't ever find this, well, we may be stuck. Attorney Deaton continues, though. Thus, if we file the case and the only evidence we have is Bill Hinman denying he knew his firm was a member of the Enterprise Ethereum Alliance, the judge would say there is no evidence Hinman acted outside the scope of his duties for his own personal gain. The fact that so many other SEC lawyers and staff helped him with the speech supports a claim that he wasn't acting outside the scope of his duties as director of corporation finance. Despite the SEC claiming it was his personal opinion in the Ripple case, does anyone seriously doubt that the SEC would show up in a case against Hinman and tell the judge that the speech was official SEC work product and therefore protected by immunity? Of course they would. Without more proof, all we can show today is a gross appearance of impropriety. Now, ignoring the ethics officer's warnings not to meet with Simpson Thacher is enough to warrant an investigation, but it's not enough to pierce through the shield of immunity to overcome a motion to dismiss. An appearance of impropriety, even a gross one, is not enough to get over the hurdle of qualified immunity in the early stages of a civil lawsuit. The judge would dismiss the case with prejudice. If a judge dismisses the case with prejudice, then it could be game over for justice. So, pause. See, this is why I'm saying that we have to take this very seriously. I get that everybody, me included, would love to move forward as quickly as possible to put people that have done wrong in the hot seat here and have them answer for their crimes or, I mean, look, at this stage, I guess we can just call it appearances of impropriety. Okay, fine. But if this went south, though, and it seems like a virtual certainty that it would based on what the attorney Deaton is saying here, if the case is dismissed with prejudice, it can't be brought again. That's the problem. That's what's at stake here. And so Attorney Deaton continues. If the case is dismissed with prejudice, it can prevent any future case from going forward, even if strong evidence of wrongdoing surfaced later. There are doctrines of law called res judicata and collateral estoppel that could be triggered by a dismissal with prejudice. If a second case was filed later with additional evidence, Hinman's lawyers could invoke these doctrines of law, and a judge could rule that the issue was already decided and that he must honor the prior judge's ruling. So I'll just pause it. I know it sounds ridiculous. This is the law system, though. Imagine the case thrown out before it even gets moving because it's qualified immunity. Does it matter that the facts and circumstances weren't analyzed back then, and that there may be new facts and circumstances, with the second filing, should there ever be a second filing? It doesn't matter. It looks like it would just likely get tossed out anyway. Attorney Deaton continues. Even worse, when we ask a congressman or senator sitting on the financial services committees to investigate, they might say, didn't a federal judge look at this already and decide it lacked merit? Imagine that. In fact, Hinman would love it. He could control the narrative. We would then have to listen to CNBC finally cover the story, except the coverage would be how it was dismissed, even though no real discovery took place. The reality is that there will likely be only one chance at filing a civil case against any former government official. So I'll tell you, the first time I was reading through this thread, upon reading it, I was like, I hope nobody screws this up for us, because you could just, if somebody gets a little bit antsy here, file something, and then it's dismissed with prejudice, that's it. So if somebody does that, then the rest of us are screwed, the rest of us who are willing to be patient. Ugh. John continues, the same applies to going after the SEC itself. In addition to qualified immunity, you have to overcome sovereign immunity. It is not an easy thing to overcome. Look at the Bernie Madoff case. Look at how egregious the SEC's negligence and conduct was in not pursuing Madoff. Yeah, and so, of course, I'm sure most of you are aware of the Bernie Madoff case, but it was one of the largest Ponzi schemes in history. I can't remember how big it was off the top of my head, but it may have been somewhere there with like $50 or $60 billion. I'd have to Google it to be sure, but it was absolutely massive. And the SEC just botched the whole process. Because look, mind you, like the firm, Bernie Madoff's firm, it was being analyzed by the SEC, but there are all sorts of red flags, and the SEC missed everything, resulting in people losing just billions and billions and billions of dollars. And for some people, is basically their entire net worth, just about horrific stuff here. And the SEC, they're safe. In fact, look at this. Here's a headline from a piece that John Deaton shared from Reuters. This is back in 2013. Victims of Madoff fraud can't sue SEC appeals court. Anyway, John continues, and with a quote from this. A federal appeals court upheld the dismissal of lawsuits against the securities regulator brought by Madoff investors. The court said the SEC's actions and regrettable inaction were protected by a law that shields federal agencies from liability. The point is that justice and accountability isn't going to come easy or fast. It is imperative that we keep asking for and demanding an investigation. Intentional misconduct and gross negligence is not fully protected by qualified or sovereign immunity, giving life to cases. Look what's been uncovered by Empower Oversight and XRP holders through publicly available information, or FOIA, Freedom of Information Act. An investigation with subpoena power brings it all home. We keep fighting. I have an appointment with a major journalist at a major publication next week. Slowly but surely. So I'm wondering who that the publication is. All will be revealed in due time, unquestionably. But this is what I was saying. We're going to have to be patient. And right now, the best thing that we can do as a community is continue to find more information, keep hunting, and there is more stuff that we can research. New stuff continues to be uncovered, which gives us new ways to approach the search. And I'm actually going to be talking about that more in my very next video, because there's a whole lot of Hinman emails that have just been uncovered. And despite the fact that they're heavily redacted, we did get some information out of this and some new ways to continue the hunt. I'm optimistic ultimately justice shall be done. But in the meantime, again, let's just keep hunting. What we need to find is proof that Billy Boy Hinman did know that his law firm Simpson Thacher was a member of the Enterprise Ethereum Alliance. But I'll wrap up there. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.